Thank you very much. Ladies and gentlemen, it's a great pleasure to be here and to have the opportunity to address this audience. My name is Daniel Sharma. I'm a disputes partner at the law firm DLA Piper, based in Frankfurt and Brussels. And apart from doing international disputes, in particular international arbitration, mainly as counsel, sometimes also as arbitrator, conflicts permitting, I also co-head our firm's global India group, which is one of the reasons why I'm speaking to you today. When we were thinking about the topic, a relevant topic for this conference, we ended up choosing the topic of renewable energy disputes for a variety of reasons. I think everyone agrees that at a global scale, the most important political topic at the moment is climate change and dealing with climate change, avoiding climate change. And of course, the most important part in these policies is the transition from fossil energy production to renewable energy production. Now, we as lawyers, we always follow the market. Sometimes we set trends, but normally we follow the market. And as a consequence of more renewable energy projects, there are, of course, also more disputes relating to renewable energies. And that's why we chose this topic for today's dispute resolution conference. To give you a few numbers, we have today approximately 3.3 terawatt of installed renewable energy capacities. By next year, the projection is that we will be at 4.5 terawatt. If you look at wind alone, today we are at more than 1 terawatt. In the next 5 years, at least 700 gigawatt will be added in wind energy capacity. And in 2022, installations were not only made, of course, in Europe and the US, but Asia accounted for 60% approximately of new renewable capacity. In India, as of February of this year, we had almost 170 gigawatt of renewable energy installed. There are some farms have the same structure, basically. There's a foundation, and there's a tower, and there's a generator, and there are blades. But it is much more complex to install an offshore wind farm rather than an onshore wind farm, for various reasons. If you want to install an offshore wind farm, you already need a ship to get there. You need good weather conditions to be able to install it. You need specialized companies that are able to install offshore. You need specialized staff. And all of this comes, of course, at a cost and of higher technical complexity, which is why there are also more disputes relating to offshore wind farms rather than to onshore wind farms. Maintenance costs are much higher for offshore wind farms because, again, you need a ship to get there. To the wind farm, you need good weather conditions, you need specialized staff. And if a part fails, you need to replace it. Again, you need a ship to get there and replace it. So offshore wind energy, I would say, are among the most complex projects in the area of renewable energy. But we have, of course, also solar energy, which is particularly relevant for India, and in particular more relevant for the global south than for the north, of course. We see hydropower projects and we see a lot of bioenergy projects, although from a dispute resolution perspective, they are probably a little less innovative and less interesting than the wind stuff that I was just talking about. To summarize, the specific features of renewable energy projects are high technical complexity, a very high degree of regulation. Wherever you go, and I'm sure it's the same in India, but wherever you go, regulation for renewable energy is just very, very complex, and it continues to become more complex with new technologies coming in. Regulation will also have to catch up, and that's a big part of the legal work relating to renewable energy projects. I talked about continuing maintenance, very important topics for wind farms in particular, and then something that's very specific, a very specific feature for renewable energy, it's the external factors. If there's no wind, there's no energy being produced. If there's no sun radiation, there's no energy being produced. That's unlike coal or other fossil energies. This has an implication, of course, for contractual arrangements between the parties. Has an impact on funding and funding mechanisms for these projects, because you need to find a lender, or to put it differently, a lender will want to see the conditions of revenue in order to be able to fund a project, a wind project or a solar project. And then on the right-hand side of this slide, you see the main actors in a typical renewable energy project. You have the contractor, along with subcontractors. In almost any larger project, there are subcontractors because we're talking about technically highly complex projects. You have the purchaser, so that's the employer. You have the maintenance provider. Sometimes the maintenance provider and the contractor are the same person. And we see the lenders. And probably one party is missing here on this slide. I would also add the energy distribution companies, the power distribution companies, because they play a very important role in the whole arrangement, in particular when it comes to funding and purchase obligations at fixed prices that you see in statutes all over the world. What are typical dispute scenarios in the area of renewables? Quite often they turn around pricing, price increases. With the pandemic starting mainly in 2020, we saw a dramatic increase in raw material costs, in transport costs, which are all very relevant for construction of wind farms, for example. And the parties were trying to find solutions in their contracts. But this was particularly difficult in contracts that were concluded before the pandemic, but implemented after the pandemic started. Because the calculations for these contracts concluded before the pandemic did, of course, not take into account that something like the pandemic and a dramatic increase in costs could happen. As lawyers, we would, of course, immediately point to contract provisions on force majeure. Plenty of discussions and plenty of litigations and arbitrations around the world. I think there's no uniform solution. Those rare animals who had put in pandemic in their force majeure clause were lucky, but really there weren't many, at least in my practice. So disputes about pricing, in each and every contract you will see price escalation clauses. But then again, in many cases there's dispute about the benchmark that is being applied. If parties use the benchmarking model, they try to evaluate their current cost in the project and compare it to the benchmark chosen. In many cases, as a benchmark, the parties chose the statutory feed-in tariffs guaranteed by the state. Now, in the last year and a half or so, we were in a situation where energy prices increased dramatically and increased beyond the level of the guaranteed feed-in prices in the statutes. The consequence of this was that if a contractor wanted to ask for additional pricing for additional money, or if there were losses caused by a contractor's failure, and no generation of power as a consequence, the employer, the purchaser, told the contractor, my damage is much higher than only the feed-in tariff. My damage is actually the market price, the higher market price that I was not able to achieve because of your failure. And you can imagine that there were many discussions, and there still are many discussions in dispute resolution proceedings about these benchmarks. Because these renewable energy projects are quite complex, quite costly, you will see that in these projects more than one or two companies play a role, and as a consequence of that, joint ventures are created, and we have the typical joint venture disputes, but these mainly are corporate disputes, so nothing special for lawyers used to doing dispute resolution, commercial dispute resolution. One specific scenario that we have seen is in wind energy again is the question of responsibility matrix. In wind energy construction contracts, you will always find a responsibility matrix which defines which party bears the risk of which element of the whole project. Now, we recently had a dispute where we were dealing with an offshore wind farm, and the offshore wind farm failed to generate the numbers that the parties had envisaged, in particular the purchaser. And the reason for that was that there had been a maritime accident. The cable between the wind farm and the mainland was damaged, and no power could be transferred from the production side to the distribution network. This was a situation that was not reflected in the responsibility matrix of the contract, and so the parties got into dispute about who had to pay the money for it. What does that mean for counsel or for lawyers advising companies, advising their clients? Try to think of any and every scenario that you can think of and what you have seen or heard of in order to reflect it in the contract. And then, of course, we have the typical disputes relating to delays in big construction projects. You always have them, and the warranty cases when there's a part that's not working. The consequences, I think, are not different than in other cases in other industries. We've got financing investment disputes. I'm not going to detail here. On the right-hand side of this slide, so I was talking about civil disputes now. On the right-hand side of this slide, you will see public law disputes. Before a project can start, of course, a permit needs to be acquired. And you can imagine that there's all sorts of disputes that come into play here. Something that's very relevant, at least in my jurisdiction in Germany, is the last bullet point. For onshore wind projects, also for solar projects, the neighbors of these projects almost always file complaints against the project because they fear that the value of their property will decrease if there are high towers just next to their land. While we have seen in the past that courts were quite ready to follow the view of the neighbors, we are now seeing a shift in priorities. Certainly, also caused by the recognition, also not only by politics but by the judiciary as well, that renewable energy projects need to be facilitated if we want to achieve the Paris Treaty numbers, for example. So not more than 1.5 degrees Celsius in higher temperatures globally. So renewable energy disputes can be complex, and they involve a range of legal, technical, and financial issues. Having described what can happen in a project, there are also dispute avoidance and risk mitigation strategies and tactics, of course. Renewables have challenging features. One is the intermittent nature of renewables. So either there is wind or there's no wind. If there's no wind, there's no energy production. How do you deal with that? I mentioned it a couple of minutes ago. The lenders will want to see a steady revenue, of course, so that loans can be repaid. And the legislators have found solutions to that, and it's a scheme that you will find almost all over the world. There are purchase obligations on the distribution companies and purchase obligations at fixed prices. Next challenge, high frequency of regulatory changes. If you see the development, the technical development in renewable energies, you can imagine that there's a constant change also in technical requirements and then also in technical regulations that need to be satisfied by the parties. So it's very important that parties deal with these issues in contract provisions in an appropriate way that leave it open to the parties to amend their contracts if need be. And then last but not least, there's a large volume in renewable energy cases of proprietary equipment. Very rarely we're seeing EPC contracts here where you have only one company that's responsible for everything. Because of the complexity, you will almost always see more companies involved. And accordingly, if there are more companies involved, if there are more players in the picture, there's more potential for disputes, and you need to find good legal arrangements in order to avoid them as far as possible. Importantly, and this is really something I would like to address to in-house counsel here in the room, your internal clients need to be advised in relation to the applicable law. In international projects, always analyze which law is the best for your company's interest, for your own interest. There might be differences between common law statutes and civil law perspectives, but all of that is disputed. I would always recommend that you as in-house counsel or with the help of outside counsel analyze which law really provides for what you're looking for, what your interest is. And this needs to be done, obviously, before a contract negotiation starts. Now, moving away from legal considerations, I would like to mention a few operational points that we have identified as being important in our practice, in our disputes practice. So to-dos for internal organizations. The first one is have a clear responsibility matrix. You need to know in your internal organization which internal party is responsible for which part of the project. And the matrix needs to include not only the project team, but it definitely needs to include someone from finance and someone from legal as well. So this is very important as of the start of the project. Secondly, organize the correspondence with your contract partner or contract partners. There literally is this one email that can be worth millions in a dispute. If you find it, it's great. If you don't find it, it's a real problem. And that's why it's so important to have a good document management system, to have discipline within your team. Don't lose this one email, that's so important. And last point here, goes in the same direction. Minutes of meetings, always record what you have agreed orally with your contract partners. We have recently seen a case where the contractor agreed with the employer that a certain milestone that was identified in the contract could not be reached, so the milestone was suspended. But there was no minutes of meeting reflecting this. There was no signed protocol or anything like that. The day of the milestone came, and the employer was waiting for the milestone to be fulfilled. And as there was no evidence that came to the help of the contractor was in real trouble here. Last slide on risk mitigation. If a dispute, a real dispute is imminent, obtain legal advice. At the latest, at that point in time, obtain legal advice. We always recommend to get legal advice as early as possible. You should start with your internal lawyers if you have some in your company. Otherwise, use your outside counsel. But it's money well spent. And I'm not talking now in my own interest as a lawyer. I'm talking on the basis of quite some experience in the area. If you involve legal advisors at an early point in time, if you see that a dispute might arise, it's money well spent. Because if you know that your legal position is good, you might be able to convince the other side that it should settle. If you see, and you want to know it, if you see that your legal position is weak in a project, then you'd rather settle at an early point in time in order to save costs that you would otherwise incur with a formal proceeding. The same applies to technical expertise. Basically, the lawyers, your legal counsel will always need the technical expertise to apply the law to the facts, right? So you need technical experts. Of course, there are the in-house experts. Sometimes they have been dealing with the project for a while. They have their own interest. Maybe they don't have a neutral view of what's happened really technically. So it's always a good option to hire outside technical counsel experts as well. And in any way, if you have to go into arbitration or litigation, it's almost sure 100% that you will need your own independent expert. And last but not least, a point that's also quite relevant that we've seen many times, fact witnesses. We're talking about an industry that's booming, and accordingly, there's a lot of shift, turnover in staff, so people get good offers from competitors, move over to competitors. But what do you do if someone who is a really important fact witness, who has worked for your company for 5 years, has now moved to another company and is no longer available as a fact witness in an arbitration? So you want to try to secure the help of these people as quickly as possible and as early as possible. So very practical recommendations. Please think about them. My time's up. I just want to talk about this last slide. There are different means, instruments of resolving disputes. You know all of them. They're not different in renewable energies than in other sectors. Of course, the last two, litigation, arbitration, provide for binding decisions. And I would say if you look at international projects, probably arbitration is always the best solution unless there is a bilateral treaty on enforcement of civil judgments by state courts, but this is relatively rare. So I would, in international projects, always recommend to go for arbitration. That brings me to the end. Thank you very much for your attention. I'm around all day, so if you have questions or would like to discuss anything, I'd be more than happy to do so with you. Thank you.